Okay, let's go on the record in the people of the state of California versus Carlos Reales Dominguez. This is case 23-1391. Prosecutor DeMora, Prosecutor Vanderhook, Defense Attorney Hutchinson, and the defendant Carlos Reales Dominguez present with us. And we have 18 members of our jury present, and it's great to see everybody here on a windy day. Everyone was on time. A great way to start a jury trial. I'm so thankful for your service, and I know our entire community are thankful. We're going to get going here right away. As a practical matter, I've got 3 of my jurors over here on the left, and I am going to move you slightly to the right, but we live stream these proceedings, and I don't want any of the jurors on the live stream proceedings. So I had to put you over there temporarily. I'm going to tighten up the camera angle, and then we'll be able to move you out a little bit. So thank you for your patience today with me on that. Okay. So let's move on and get started here. So the first thing I'd like to do for the jury is to read the information to you. And this is the charging document. Count 1. On or about April 26, 2023, Carlos Reales Dominguez did commit a felony, namely a violation of Section 187, Subdivision A of the California Penal Code, murder, in that Carlos Reales Dominguez did willfully and unlawfully kill a human being, to wit, with the initials DB, with malice aforethought. It is further alleged that the murder alleged above was willful, deliberate, and premeditated within the meaning of California Penal Code Section 189, Subdivision A, an enhancement for willful, deliberate, and premeditated murder. Count enhancement 1A, it is further alleged that during the commission or attempted commission of the felony charged above, Carlos Reales Dominguez did willfully, unlawfully, and personally use a deadly or dangerous weapon within the meaning of Section 12022, Subdivision B1 of the California Penal Code, use of a deadly weapon. Moving on to count 2. On or about April 29th, 2023, Carlos Reales Dominguez did commit a felony, namely a violation of Section 187, Subdivision A of the California Penal Code, murder, in that Carlos Reales Dominguez did willfully and unlawfully kill a human being, to wit, initials KA, with malice aforethought. It is further alleged that the murder alleged above was willful, deliberate, and premeditated within the meaning of California Penal Code Section 189, Subdivision A, enhancement for willful, deliberate, and premeditated murder. Count enhancement 2A. It is further alleged that during the commission or attempted commission of the felony charged above, Carlos Reales Dominguez did willfully, unlawfully, and personally use a deadly or dangerous weapon within the meaning of Section 12022, Subdivision B1 of the California Penal Code, use of a deadly weapon. Count 3. On or about May 1st, 2023, Carlos Reales Dominguez did commit a felony, namely a violation of Sections 21A, 664 sub A, and 187 sub A of the California Penal Code, attempted murder, in that Carlos Reales Dominguez did willfully, unlawfully, and with malice aforethought attempt to murder the initials KG, a human being. It is further alleged that the attempted murder alleged above was willful, deliberate, and premeditated within the meaning of California Penal Code Section 664, Subdivision A, and 189, enhancement for willful, deliberate, and premeditated attempted murder. Count enhancement 3A, it is further alleged that during the commission or attempted commission of the felony charged above, Carlos Reales Dominguez did willfully and unlawfully and personally use a deadly or dangerous weapon within the meaning of Section 12022, Subdivision B1 of the California Penal Code, use of a deadly weapon. Count enhancement 3B, it is further alleged that during the commission of the felony charged above, Carlos Reales Dominguez did willfully and unlawfully and personally inflict great bodily injury upon any person other than an accomplice within the meaning of Section 12022.7, Subdivision A of the California Penal Code, infliction of great bodily injury. Case Enhancement A, it is further alleged that the offenses charged in counts 1 and 2 involved the murders of 2 separate victims within the meaning of section 190.2, subdivision A3 of the California Penal Code, special circumstances for multiple murders, in that Carlos Reales Dominguez murdered more than one person, to wit, humans with the initials DB and KA. That's a reading of the charging document in this case. Now I'd like to offer some baseline jury instructions to you. The trial will now proceed as follows. The people may present an opening statement. The defense is not required to present an opening statement, but if it chooses to do so, it may give it either after the people's opening statement or at the beginning of the defense case. The purpose of an opening statement is to give you, the jury, an overview of what the attorneys expect the evidence will show. It is not legal argument. It is simply a preview of the evidence, and we're going to start this in just a minute. After the opening statements, the people will offer their evidence. Evidence usually includes witness testimony and exhibits. After the people present their evidence, the defense may also present evidence, but is not required to do so. Because the defendant is presumed innocent, he does not have to prove that he is not guilty. After you've heard all the evidence, and before the attorneys give their final arguments, I will instruct you on the law that applies to this case. And after you've heard arguments and instructions, you will go to the jury room to deliberate. Now, this trial has a special instruction. The defendant has entered pleas of not guilty and not guilty by reason of insanity. The procedure for this case is to try the question of guilt first, and then, if necessary, to try the question of insanity separately. These are 2 distinct phases. And I just a moment ago outlined phase 1, opening statements, evidence, legal instruction, argument, and deliberation. That's the outline for phase 1. That's all you need to concern yourself with right now. You, the jury, shall not consider the question of legal insanity in the first phase. You may consider, however, evidence of the defendant's state of mind in the first phase. Also, you shall not consider at any time anything that was stated on the jury questionnaires or stated during voir dire, jury selection. Jury selection serves a specific purpose. Upon its completion, it has no bearing in this case. I will now explain the presumption of innocence and the people's burden of proof in the initial phase of this trial. The defendant has pled as indicated not guilty. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You, the jury, must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proven their case beyond a reasonable doubt, you, the jury, must impartially compare and consider all the evidence that's received throughout this trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. You, the jury, must decide what the facts are in this case. You must use only the evidence that's presented in the courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The fact that the defendant was arrested, charged with a crime, brought to trial, is not evidence of guilt. Nothing that the attorneys say is evidence. Their opening statements, which we'll hear in just a minute, and the closing arguments, the attorneys discuss this case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant if they help you understand the witnesses' answers. Do not assume something is true just because a lawyer asks a question suggesting it is true. During the trial, the attorneys may object to questions asked of a witness. I will rule on the objections according to law. If I sustain an objection, the witness will not be permitted to answer, and you must ignore the question. If the witness does not answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, disregard it. Do not consider it stricken testimony for any purpose. You must disregard anything you see or hear when the court is not in session, even if it is done or said by one of the parties, one of the attorneys, a witness, or even myself. We have a transcript being made of this record. If you decide during jury deliberations that you need to review the record, you may ask that the transcript be read back to you. You, the jury, alone must judge the credibility and believability of witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or any prejudice you may have. You may believe all, part, or none any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating witness testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Here are some factors, and I'm going to give you written instructions so you don't have to remember all this, but here's some common sense factors in evaluating witness testimony. How well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as a bias or a prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is to be decided? What was the witness' attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all of the other evidence in the case? Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see it or hear it differently. Okay, my final instruction before I invite the lawyers to give opening statements. If you receive any information about this case from any source outside of the trial, even unintentionally, do not share that information with any other juror. If you do receive such information, or if anyone tries to influence you or any juror, you must immediately tell the bailiff. You must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. Bias can affect what we notice and pay attention to, what we see and hear, what we remember, how we perceive people, and how we make decisions. We may favor or be more likely to believe people whom we see are similar to us or with whom we identify. Conversely, we may disfavor or be less likely to believe people whom we see as different. Although we are aware of some of our biases, we may not be aware of all of them. We refer to those biases as implicit or unconscious. They may be based on stereotypes we would reject if they were brought to our attention. Implicit or unconscious biases can affect how we perceive others and how we make decisions without our being aware of their effect. You, the jury, must not be biased in favor of or against any party, witness, attorney, a defendant, or alleged victim because of his or her disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must reach your verdict, finally, without any consideration of punishment. All right, those are pre-instructions that the court has given to the jury, and I think I promised all 18 of you that I would wave a proverbial flag each time we moved into a new stage, and we're ready now for opening statements. Okay? So with that, I'll invite